You're Free to Go is sponsored by Milburn Men's Clothing, where top athletes shop for sharp, tailored style. And whether Mark and I are in the studio or the courtroom, Milburn dresses us for success. Mention YFTG and get 10% off at Milburn Men's Clothing, which has been providing the finest in men's clothing and suits since 1946. Call 651-645-2922 or visit www.milburn.com. Hey, everybody. Thanks for coming back to your favorite podcast, You're Free to Go. And we're back here in Boca Raton recording. Mark, great to have you from California as always.
Great to be back.
Yeah, right here at Podcast Junkeez with our favorite engineer, Ben. So here we go today. You know, I want to start before we get into a crazy-ass cases, I just want to share with the audience something that we've learned about, and it's been a really positive thing for us. You know, we never anticipated that young people would listen to this podcast. And I keep getting calls from friends saying their kids are loving it. And what's cool for us about that is that these will be the future lawyers of our country and
or clients.
Yeah, hopefully not. Yeah, hopefully not. They're learning how to pull off the perfect crime. Maybe
Right.
I hope not.
Well, if it's the perfect crime, they won't need us.
So don't pull off the perfect crime. Yeah. So you know, I just want to share too. You know, I have a single mother who has two boys, and they've created a family activity where they literally sit around the table in the evening every Friday when our podcast episode drops, or over a weekend if they can't do it on Friday, and they listen and they talk about the podcast, and it's really become a bonding experience for her with her two boys, which is really cool. And then they're so interested in it that I've already talked with them about bringing them to court so they can see, you know, a trial or some hearings or something like that.
That's great.
You know, my other buddy, and this is really significant because it leads into the case I want to talk about. My other buddy has a 7th grader named Mason, and he and Mason drive to school on the mornings. My buddy drives his son Mason to school, and very often they'll listen to our podcast, and then my buddy will text me questions that Mason has, which is so cool because it shows that he's really picking up on legal nuances and really interesting questions, but that he's paying attention and he's learning a lot. And again, you know, it's encouraging because this is a generation of attorneys. But what it brings up for me is that we didn't realize there may be kids listening to this. And what we talk about is often in criminal law, criminal defense can be a sensitive topic like sexual battery, like, you know, violence. You know, those types of topics are they're R-rated. And so parents need to be a little bit aware, you know, before they just let their children listen to an episode, that, you know, some of them might be a little more sensitive.
Well, we're certainly not going to be looking for a PG rating here.
No, not in
Or
this
a G
topic.
rating.
Right. In fact, when we have interns, you know, work for us, you know, we can't really have high school students because obviously confidentiality issues, which they don't understand. But sometimes, you know, there's a case that involves a sexual battery or some type of other, you know, really serious crime that they're just not mature enough to handle or to be and shouldn't be exposed to.
So what do you got for us today?
So today is definitely R-rated. It's a tough case. There were 6 boys, 5 were minors. So there were 2 boys that were 13 years old, 2 that were 14 years old, a 16-year-old, and then an 18-year-old. So that 18-year-old would actually be in adult court. And they were all arrested and accused and charged with the sexual battery, which, you know, most people refer to as rape, but the legal term is a sexual battery. And there were 2 victims. They were female, the victims, and the 2 victims were 13 years old.
Oh, wow.
It was a really, really disturbing, you know, situation. It was very much in the news because the 2 victims are victims. They can, under several laws, they can't disclose their names in the media, and the boys being juveniles, they couldn't disclose theirs. But the 18-year-old, his name was in the media. It was covered in the media a lot without disclosing names. So it was a very serious event. It was on the west coast of Florida, over there in the St. Pete area, and actually it occurred on the ocean. And what happened was these kids were these 6 boys with the 2 girls were having sex at the beach, and there was 8 people, and it got loud, and they were, you know, there was no evidence of screaming or yelling, rape or anything like that. It was just laughing and joking around, horsing around. There were homes on that beach. One of the homeowners heard it and just didn't feel comfortable. It was late at night. It was like 2 a.m. Wasn't comfortable with what they heard. So they called the police and said they were really calling more because of a noise violation at that hour of the day. And the police, they come walking up because it's on the beach, and they see the 6 boys from a distance as they're walking up. They see the 6 boys jump up, pull up their pants, and run. They take off. The police continue to come forward, and the 2 girls don't jump up and run off. They're still there kind of trying to put clothes back on. But when the police actually get to them, they're still naked, and they're fumbling, trying to put clothes on. The girls are extremely, extremely drunk. Again, 2 13-year-old girls. As I said, a very difficult situation. And so the police are now trying to investigate and figure out what the heck is going on here, right? So what they wind up doing, and we know that people refer to a term called statutory rape. If someone's under 18, there's no consent. So someone can't consent to a sexual battery under the age of 18. So you could be a minor and charged with sexual battery on another minor. And that's what basically happened here. The 6 boys got charged.
So you can be 14, for example, and have sex with another 14-year-old, and you could be charged with sexual battery?
That's right, yeah. And sometimes...
So the age of the female is the issue. But what if it's... Why isn't she charged with sexual battery on a 14-year-old boy?
Right. So it's so good that was partly my question, and the prosecutor took a strong position that these girls were too inebriated to say no.
Yes,
they were too wasted to be able to stop it or push back and say, no, I don't want this. So that's why they chose to prosecute
This was at night.
Yeah, it was very late.
At what time?
2 a.m.
So, it begs the question. It's not a legal issue, but it's a practical... As a parent, I'm wondering, what the heck are these 13-year-old girls doing out at 2 a.m? Where are the parents?
Right.
What are they doing?
So we do see that issue a lot, and the answer in this case was that it was the Christmas break. It was the December week before New Year's, and it was very festive. Everyone's out at house parties and so forth. And
13-year-old girls at a house party?
Right. I know. I'll share with you a little more in a minute. That I think you're going down the road that it puts in question what's their credibility. Who are they? Of course, no one ever deserves to have this happen to them.
Sure.
But their credibility comes into issue in every case we handle. And then these cases often, when you have these sexual batteries, like you just pointed out, where they're minors, very often they come down to the parents. Some parents say, I don't want this prosecuted at all. And some parents say, oh, I absolutely want this prosecuted. Initially, in this case, the parents of the 2 girls really wanted it prosecuted aggressively. And I could understand that as a father of daughters.
I think they should have been investigated for allowing a 13-year-old out at 2 in the morning.
Absolutely. Absolutely. Department of Children and Family Services should get involved in those situations. So they did pursue it. I want to share a little bit about, so people kind of learn more about what we do as criminal defense lawyers and how we handle cases. So with all of the 6 boys, there were 5 other defense attorneys. So I had 1 defendant, and the 5 other boys had attorneys.
Yeah, I don't think most of our viewers understand that it's almost universally, there are exceptions, of course, inadvisable to represent more than one person if they're charged jointly with a crime.
Right.
Because there could be different theories of defense. One might be more culpable than the other. One might have different arguments than the other. And if you're representing both of them, then it's a problem.
That's right. It's extremely rare, if almost never, that we can represent. I'll give you an exception, though. When Rod Stewart got arrested, I represented him and his son. They both got arrested. We entered a joint defense agreement, which we understood that if things, progressed to a point where there was an adversarial relationship between the 2 of them, we would either I would have to withdraw from both, and they'd each get new lawyers, or I'd continue to represent. And let me correct myself, Sir Rod Stewart, because he is knighted. And then I could continue with Rod Stewart, and his son would get a different counsel. But it's very, very, very rare that we represent more than one.
Well, I had a husband and wife that wanted me to represent them. And I'm happy I didn't, because 3/4 of the way through the trial, they separated and ultimately got divorced.
Yeah, exactly. That's why, the judge will look at it and say, we can't anticipate what may happen down the road, so we can't let you represent both of these people. What happens if
They want to save money, obviously.
Right.
One lawyer versus two.
Right. But what if at one point the prosecutor says to you, hey, for the husband, if he turns on the wife, we'll drop his charges.
Well,
Right.
that was a routine. When I represented organized crime, people accused of organized crime, a lot of times the government would charge the wife because they knew that my client was a stand-up guy
Yep.
who would take the hit,
For the wife.
take the beef, as
Yes.
you would call it,
Yeah.
for the wife. Yeah. And then they drop the wife, and he would plead guilty. And that was a lousy move on the part of the government to do that.
Just like defense attorneys have strategies and tactics, the prosecutor does too,
Right.
and they're usually overhanded like that. They're rough on us sometimes. It's unfair.
So anyway, getting back to
Yeah.
this.
So the 5 other attorneys, this is where you and I are different compared to most criminal defense lawyers. Most criminal defense lawyers just look at the facts in a case and they argue the law. You and I spend a lot of time on the strategy and how to navigate the system, and in addition to looking at all the legal issues and fighting those issues.
I
So
think that's good attorneys do that. It's not just we do it, but I
right.
know a lot of others.
Yeah, the really good lawyers do it, but most don't. Most get so focused, they get stuck in the weeds of the legal issues, and they don't look at the big picture. How do I navigate this process to get the best outcome for my client? And we've talked about the great Roy Black, may he rest in peace, before. I learned that from him. He showed me how to really manage a case. So these 5 other defense lawyers were freaking out because all they wanted to focus on was the legal issues, and they hear from me when we have like a meeting as lawyers that, I've been talking to the media and I've been talking to the victim's parents. They're like, whoa, what are you doing? What are you doing? I'm managing this case, and this is a strategic approach. The media, as you know, these journalists, investigative journalists, know more about a case than the prosecutor, than the police officers. These guys are incredible, and they're feeding me information about the investigation that I either never would have gotten or would have taken months through the discovery process, the legal criminal justice process and procedure, that it would take months for me to get this information. I'm getting it from these investigative journalists, like right out of the gate. So that's one of the reasons I'm telling these other lawyers, this is why I'm talking to these media. And although the bar rules prevent us from trying a case in the media, there are statements we can put out there. So I'm talking to the media because all the articles up to that point were really going hard against these 6 boys.
Yeah, that's a tough decision. You got to be careful how you do it. But on the other hand, when you're facing an onslaught of negative media, and which is going to not only taint the community and the potential jury pool,
Correct.
how do you deal with that? You've got to fight against it somehow. The only problem is the media, understandably, they like bad news.
Right. Yeah, they do.
Good news they don't like to
Right.
publish.
Yeah, but you know what I find is because you and I have had so many high-profile cases, they won't burn us because they know if they burn us, they'll never get another statement from us.
Because they always want information.
Right.
So it's a give and take. The good reporters, they know that, they're, and some you can rely on to do off the record, although most of the time, to me, off the record doesn't exist.
Correct.
But there are a few that you get to know, and it's a give and take.
Right. No, and that's been my experience too. And they, I'll be happy. We continue to get high-profile cases, and they continue to want to talk to us. So they typically work with us, the media. And I just want to put out there that, so hey, don't judge this case so quickly. Let's get to the courtroom and let the facts come out before any decisions are made. Because, like we said, it's a sensitive topic. We can't actually argue the case in the media pursuant to the rules, but we can plant some seeds like that for, as you said, potential jurors, because there's a chance a case will go to trial. So the other thing I did was reaching out to the victim's parents, which freaked the 5 other defense attorneys out too. And I do that because we're allowed to under the rules of procedure. Of course, if they say we have a lawyer, we don't want to talk, we say, thank you very much. Maybe please have your lawyer contact me, and we discontinue the conversation. But if they want to talk with us, we're allowed to have that conversation. And I find out what's going on with their daughters, how we can help them. Do they need any help? I had a wealthy client, and he was willing to pay for therapy and whatever they needed and so forth. And so I opened a dialogue, which was great because the parents continued to talk with me throughout the litigation, which was valuable. And they understood. Some people think, well, how could a defense attorney talk to the victims? But it's actually, if I'm helping them, I'm helping my client as well. It happened in the Jeff Epstein case, actually, where, the victims in that case, they needed things. They needed services. They needed help. And by me reaching out to them and getting them help, it not only helped them, but it helped my client. So there's nothing in conflict there. So it was funny how these defense attorneys, they started to see a whole different way to practice criminal defense, which was cool. As a little side note, an interesting situation that occurred during this case, my client's parents were going through a divorce. And it was there was a lot of animus between them. It was very sad. And I got subpoenaed to a divorce hearing by the mother's attorney. And the purpose of it was they were arguing, and you and I are not divorce attorneys, but what they were talking about was parental alienation. The mother of my client, who was a juvenile, was arguing, her lawyer was arguing that the father is doing all sorts of things to alienate their son, my client, from the mother. And they called me to say that during our client meetings, where, typically we only meet with the client in the room because it's attorney-client privilege, but as a juvenile, the parents were in the room as well. And they were arguing that in our meetings, the father would say very derogatory things about the mother in front of me and in front of the child. Don't listen to your mother. She doesn't know what she's talking about.
Nothing worse than a husband and wife in a divorce situation. They say, it's an old saying that divorce lawyers see the best people at their worst and criminal lawyers see the worst people at their best. And I've always said, I have a lot of respect for divorce lawyers. I could never do that. I would rather represent Al-Qaeda than a husband or wife in a divorce.
I know. Which, by the way, on the other hand, we'd be much richer because those cases never end.
They never end.
Never end. 30 years later.
If you hire lawyers, and this is no disrespect for divorce lawyers, what happens a lot of time at the end of the day, the divorce lawyers have the money and nobody else.
Right. Yeah. There goes the kid's college fund. Right. So it was really interesting. So I thought when I got subpoenaed, I called the wife's lawyer. I'm like, why are you subpoenaing me? She tells me. I'm like, well, everything's attorney-client privilege. I can't talk. And she's like, well, we're going forward anyway. Maybe we'll see. Maybe the husband will drop or, the case or something. So I call the Florida bar and I'm talking to them, what's going on. And it turns out that the way you're supposed to handle this is you go before the court, you get subpoenaed, you get in the witness seat, you make the lawyer ask you the question, and then you turn to the judge and say, Judge, the answer to that question will reveal attorney-client privilege information. Are you directing me to answer that question?
Right.
And if the judge says, yes, I'm directing you to answer the question, then we're allowed to answer the question. Yeah. So it was a really, really interesting situation that arose.
So what happened in the case, ultimately?
Well, here's what was interesting. We get to a plea. We negotiate. I don't want to get too much into the details. I'm going to share one very significant detail in a moment, but it's such a sensitive issue. I don't want to really talk about the facts and allegations and so forth because these were young kids and it's a difficult case. But an interesting scenario that occurred is that I negotiated a plea offer. My client is a minor again. He's so young. His father is a lawyer, actually. And he knew me in the community from Florida, even though he's on the West Coast. I'm based out of the East Coast in Boca, but he knew me from cases I've had in the Tampa area. And he was objecting, and I'm going to use the word vehemently. He was vehemently objecting to the son taking the plea. And the son was like, no, I want to take the plea.
Now, he was in juvenile court?
In juvenile court, yep. I'm sorry. It started in juvenile court, but they moved it all up to adult court, believe it or not.
How old was he?
Yeah, my client was 14. There were 2 13-year-olds, 2 14, a 16, and an 18.
So a 14-year-old, I'm not familiar with this, it's not the area that I practice in criminal law. A 14-year-old can be charged in adult court?
Right. There's two ways they can do it. I haven't looked at that statute in a while. Maybe there's some amendments to it. But basically, if you have a long series of prior criminal arrests in juvenile, they can automatically file you in adult court. Or if the prosecutor, through a team at the prosecutor's office, determine that you committed an adult crime, it's kind of very vague and ambiguous, they have the power to put you in adult court. It's all in the power of the state attorney's office.
Wow.
Most states call him DA, district attorney, but yeah, as you know, Florida's a state attorney. Yeah, so that's how they moved it up. They felt this was an adult crime. There's an 18-year-old involved. And they put it in adult court. And so what was really, this is another scenario where I had to call the ethics bar, and I did some research. And I find out, well, geez, my kid's a minor. He's not old enough to consent under the law, right? We talked about it a few minutes ago. Well, how is he old enough to make the decision to take the plea?
When the father is objecting.
Not only is he objecting, but he's a lawyer himself.
Right.
Turns out that the bar and ethics rules and so forth are very, very clear. There's case law on this, that the client, no matter how old they are, it's their decision to make. And I was so proud of this young boy because he stood up to his father, because his father, he did not want him standing in court. The plea offer was, we're going to plead no contest, right? We're not pleading guilty. We got the same deal for all 6 boys. No contest, as people may know, means I'm not saying I did it. I'm not saying I didn't do it. I'm just choosing not to contest this case because I know if it goes to trial, there's a chance I could be found guilty. There's a chance I could be found not guilty. So I'm entering a I'm withdrawing my plea of not guilty, changing it to no contest.
And what was the sentence?
The sentence was 1 year of an ankle bracelet. It wasn't technically house arrest. The boys were supposed to be on house arrest.
Basically being monitored, right?
Correct, being monitored. They were allowed to go to school, any after-school activity, constructive, productive things, right? They were allowed to go have dinner with their family at a restaurant and so forth. They just otherwise were supposed to be at home, and they had this monitor. And the son said to the father, and at the end, it actually would be eligible to be expunged and come off their record. So the son was, I'm absolutely going to stand up in court. The father wanted him to take it to trial. You did nothing wrong, type of thing. At the end of the day, the young boy stood up to his dad. I want this plea, as well, like the 5 other defendants realized it was the best deal too, and he went forward to the court. So the real question, the one little fact scenario that I'm going to share, and again, it's very sensitive, especially if they're young people listening to this, so beware, parents. The main way I broke this case was not only that I got the victims to come on board with the result, because earlier in the evening, and this kind of goes back to your thing, what's these kids doing out at night? There was a house party. And this is really sad, but there was a video taken that I got a hold of through a good private investigator of a bunch of boys, or like 10 boys sitting in chairs, some on couches, kind of like in a circle. And these 2 young girls were giving each of these boys oral sex about an hour before this incident on the beach. It was just a wild group of kids, very sexually, energized. And that what was going on just an hour or so before. Wow. And, when I was able to sensitively, because I had opened this dialogue with the parents, I was now able, about 6.
And I assume they hadn't heard anything about that.
They thought the kids had gone to a house party. Oh. They had no idea what was going on.
Send a kid to a house party at 13 years old. I just don't get it.
Right. Yeah, I know.
I don't. I'm sorry. I'm a father. I'm a grandfather. I just don't get it. And believe me, I'm very evolved and very modern.
Right.
But come on.
I know. It's really unbelievable. And certainly growing up, girls at 13 weren't that sexually active like this.
Well, when we were growing up, certainly not.
Right.
I recognize there's a big change in exposure at a much younger age to all sorts of things. Just look at ads. I mean, it's incredible
how
sexual they are.
Yeah.
But still,
yeah.
But here's what I find fascinating, something you mentioned, based on the ability of a minor to consent on their own to a plea. So ponder this. You're too young to consent to sex, but you're not too young to consent to a sentence that could put you in jail.
Right. It's really remarkable.
Doesn't make sense.
Right. Well, I think let's remember there's that checks and balance where the judge goes through what we refer to as a plea colloquy, and they ask a lot of questions. Are you thinking clearly? Have you asked every question you want? Have you gotten answers you want? Do you think you have all the information? And the judge ultimately makes a determination that this person is, competent and fully aware and knowledgeable and making a sound decision on their own behalf. The judge does. So I think the judge could possibly deny it and say, I understand you have the right to make this plea, but I don't think you've really thought it through completely.
Well, that's a fascinating case. And
It is.
obviously, you handled it very, very sensitively. You got a good result for the client. You probably made an enemy of the father.
Right. I hope he's not listening.
Well, it is what it is.
Yeah. But, so we will continue to address issues that are sensitive, like child abuse, sexual abuse, and violent acts. And we'll hopefully, maybe we should going forward rate our PG or R, rate our episodes.
Well, I got a violent act to talk about.
I know it's a good one.
Murder on the high seas.
All right, everybody, ready for this?
And I'll make it quick.
But before you go quick, we do need to do
another
a sponsor. They
right?
pay for our show, Mark. You're Free to Go is sponsored by Lang Realty, South Florida's premier residential real estate broker. Whether you're buying, selling, or renting a home or condo, Lang's experienced realtors are standing by ready to help you. Contact one of Lang's top realtors today at 561-703-2427.
Okay, we're back. And as I promised, I'm going to talk about murder on the high seas. First of all, this was a case that was in federal court. Normally, almost exclusively, murder cases are done in state.
True, yeah.
And the reason is, I'll give you the facts. I'll set the stage. Two brothers go to a yacht brokerage and tell the broker that they're interested in sea trialing a boat. Mm-hmm. This was like a 30-something foot boat with high-powered engines, expensive. I guess they checked out with the broker. Broker felt comfortable, but went with them.
Right.
They're out in the area outside of Fort Lauderdale, and they're going further and further out. And according to the government, they were beyond the 3-mile marker. Within 3 miles, it would be a state matter. Outside of that,
those are international waters? Is that what that is?
These are waters that are deemed within the jurisdiction of the United States. Okay. They shoot them. This is the government's version. They shoot them, dump them overboard for shark bait.
Wow.
And then they take the boat to the Bahamas. And they dock the boat at a place called Hurricane Hole Marina outside of Paradise Island. Somehow, information gets back to the government. First of all, it was known by the people in the office that these were the guys who were on the boat with the broker. The boat doesn't come back. They start calling around, wondering what's going on. Ultimately, the boat is located at the marina in the Bahamas, and there's somebody at the marina who testifies, tells the FBI, well, these two guys brought in the boat, they got off the boat.
Only two
they
people.
Said they'll be back to pick it up, and the broker wasn't with them.
So this guy testifies that only two people got off of this boat. Yeah.
So the government charges them with murder, federal murder on the high seas.
And okay.
So
when you start with this, I figure maybe these guys are going to be running some drugs with this boat. But they just they killed this guy. They show up allegedly. They just wanted to steal a boat. They drop in the Bahamas. They dock it, and then they never show up again.
Well, what happens is they get wind that the government's after them.
Surprise,
so the last
surprise.
thing they're going to do
It's come back.
is come back to the boat.
Although a lot of people, they say that when they start a fire, that they often go back to watch the fire.
Right.
Like a lot of criminals do go back to see the whole.
Well, I always suspected that what happened is they kept an eye on the boat, and they may have seen a lot of law enforcement
Around it.
the area.
So they stayed clear.
Anyway, they come back to the United States. They come back to this area here.
They steal another boat to come back, or no?
No, I guess
Okay.
they flew back or
Okay.
whatever. And then they get arrested and charged with the crime, and I get hired to represent one. Another attorney gets hired to represent the other brother. Again, a situation where you don't want to represent both.
Did you have a relationship with that other attorney? Because that's often
Yes.
interesting. Which is how you and I really first met. Was we had a case and we worked on it together, and you develop a great. Sometimes it doesn't work out as well as ours did. So you had a good rapport with co-counsel.
And he was an excellent attorney.
Good.
And a real pleasure to work with. No, it can be a nightmare if you've got somebody who represents a co-defendant who is not willing to play ball and cooperate in theories of defense that would serve both interests.
Right.
Or, there are some guys, who are assholes,
Yeah.
difficult to deal with, or their ego prevents them from working with somebody, or they're looking for the limelight. Or in worst case scenario, I remember a case where, this is an aside, but it's kind of funny. I don't know if I mentioned this before, but I was representing one wise guy, and there were two others. And there was an FBI agent on the stand. Government agents are very, very practiced at testifying.
Sure.
You have to keep your questions very tight, because if you give them an opening to explain, they will bury you.
Right.
So I constructed a very, very careful cross-examination to get the information that I needed to be able to argue in my closing argument to the jury. And then another lawyer gets up, and this lawyer, by the way, I won't mention names, but some people may know who are here in the community. He's probably passed already, but he had already been censured, disbarred once,
Wow.
got let back in the bar. He was always having problems.
I have an idea who you're talking
He
about.
got up and he screamed and yelled at the witness, and the witness just buried him. He asked, I'm sitting there, just couldn't even watch.
Right.
It was like watching a train wreck.
Yep.
And totally not only burying his client, but burying mine, totally undoing everything that I tried to carefully
You wanna
do
kill him. I
in
get it.
cross-examination. And then when he gets done, it's obvious to everybody in the courtroom that he has made a total shambles, a mess of what we tried to do, and destroyed the defense of all three. Nevertheless, he comes back to the table. His client gets up and hugs him.
Wow.
My client gets up and walks over and hugs him in front of the jury, and then comes back to me and says, "Why couldn't you have done it like that?"
Really? And could the jury hear that?
I don't know,
Because
if they
those are
heard
interesting
that.
optics.
Yeah. I don't. Well, they certainly
You know
saw
what?
him go.
Yeah.
And it was it was mind-boggling.
Right.
That happened.
Right, because if I were a juror, listening to it, I'd be like, oh, this guy's hurting his case. And then when I see that, I'd say, well,
The jurors saw that.
Right, but then they see those hugs, like, oh, maybe I totally misunderstood it. He just that's like a slam dunk he just made.
And that's when I realized, a lot of times we represent people who are in the situation they're in because of poor judgment. And that poor judgment may never end.
Yeah, true. Okay.
So anyway, getting back to murder on the high seas. So I had a great co-counsel, and we went to trial in this case, and the government brought down a prosecutor from upstate New York. Back in the 80s and 90s, the number of cases that were being made in federal court here were so large, we were growing as a district, that we didn't have enough judges and we didn't have enough prosecutors.
Right.
So we used to call them rent-a-prosecutor. Especially in the winter up north, they would love to come down, and federal judges did that too and came down to sit on cases. So this guy he's since became a defense attorney, wonderful attorney. wonderful prosecutor. So he was a hard charger in the case. And the crazy part about the case is that what it really came down to is trying to determine where this crime took place.
Right.
Where was the boat? Because if the boat wasn't outside of the 3-mile mark,
Yep.
the feds would lose jurisdiction. The only problem then would be you'd be in state court where there was a death penalty.
Oh, wow.
The feds had no death penalty
Sure.
at the time.
Right.
So we were trying to figure out how to navigate that. We wanted to get this case dismissed, but we also didn't want to be in a situation where the state could charge, because
Right.
everybody's heard about double jeopardy, but double jeopardy is essentially you can't be charged with the same crime twice,
Right.
but the exception to that is if they're different sovereigns. By sovereign, we mean the state and the feds. The feds could charge the case, and the state could charge the case. You could be acquitted in federal court and charged in state
Right.
court.
By the
Case
way,
could be dismissed in federal
right.
court.
The perfect example that everyone knows about is Jeff Epstein.
Yes.
It was originally a Florida state case. It was resolved there and pled out there, and then the feds charged him basically with the same crime again. So
Right.
same facts and circumstances and everything.
But we
So-
decided, with the client's consent, to try to get the case dismissed in federal court. So the case came down to having experts see, boat, I forget what they call them, but they're basically experts in determining the speed of the boat, the tides, the length of time,
Yeah.
and ultimately, we had our experts say, no, they were within 2.7 miles of the shore. The government had their expert who said they were beyond the 3-mile. And the case, a murder case, came down to a battle of experts
Wow.
over where the boat was when this supposed crime took place. They never had direct evidence of the crime, except one of the defendants made a statement to law enforcement, and it was very incriminating. And it brings up a very interesting point that people don't necessarily realize. There is this natural compulsion when people get caught to admit to things.
Yes. Right.
And it is, of course, the worst thing you can do. I used to have in my office, and I may have mentioned this before, a mounted plaque with a big mouth bass with its head sort of turned out and a hook in the mouth. And it said on the bottom in brass, if I had only kept my mouth shut, I wouldn't be in this situation.
That's so true. So true. And we'll sit in court and see career defendants, and the cases are being made every time against them because they confess. You're like, when are you going to realize, keep your mouth shut? Like, stop confessing, stop talking to the cops. But you're right, it's the worst thing.
And a lot of
It's
times,
the worst.
what they get caught on, and what happened in this particular case, was not that they admitted the crime, that this fellow admitted the crime. Instead, he made up a story that was so untrue that could easily be shot down by the obvious facts of what had happened, that he lost all credibility with the jury. And then he made the mistake of taking the witness stand.
So this wasn't your client. It was,
the other
the other client.
He
Yeah.
made the mistake of taking the witness stand. Now, it's interesting. In the cases, and I've tried hundreds of cases in federal court and some in state courts all over the country, I can say that the vast majority of cases, we don't put our client on the stand.
Right.
The government has the burden of proof. We attack the case through our cross-examination and other evidence or other witnesses. Putting your client on the stand is a very risky proposition. I can say that in the few instances that I have put my client on the stand, there have been mostly acquittals because they've been good witnesses and the jury believed them.
Right.
But for the most part, you put a client on the stand who is not a good witness, whatever work you've done to destroy the government's case gets undone by a client who loses credibility, the jury sees through them, and then the case is done.
True. And just to clarify, when you say put our client on the stand, it's ultimately the client's decision. They follow our advice very often if we say we're not recommending it and here's why. But we have to fully inform them, and then it's their decision. And if they choose not to testify, the judge outside of the jury actually goes through a whole colloquy.
Oh, absolutely, to determine that it's voluntary, that it's knowing all the opportunities they have. They have the right to testify.
Correct.
And the judge conducts an inquiry so that later on, if they're convicted,
right, and they didn't testify,
says, my lawyer told me I shouldn't testify. I wanted to testify.
Right, then they get a new trial. So
the judges protect the record
right.
on that. And I ultimately do leave it to the client. I do tell the client what I believe. Yeah. And what I've noticed, interestingly, is I've had clients at the beginning of the case say that they want to testify. And all through the case, they're talking about that they want to testify. And then when the government finishes their case, and it's now the defense side,
they don't want to testify.
They don't want to testify.
Yeah, I would agree with that. Most clients are like, oh, I want to tell my story. I got to have my day in court. I want it. And then you're right. As the case plays out, they'll often change their mind.
So what happened is there was a circumstantial case. There was a legitimate argument that they were not within the jurisdiction of the United States because they were less than 3 miles from the shore. But one of the defendants gets on the witness stand,
blows that whole defense.
Blows the whole defense. And of course, a lot of times when people are jointly charged and one defendant blows the defense, or the lawyer blows the defense through the case I talked about, where, by the way, all 3 wise guys got convicted, there's nothing you can do.
Nothing, right. You can't even ask for a mistrial, I know.
Now, here's the interesting thing. Because there was no death penalty, they wound up not even getting life sentences.
The other interesting thing, too, is if a client asks me, if I'm going to go to prison and I have the option between state prison and federal prison, what would be better? I'm going to tell them federal prison anyway. So it also worked out in that sense that it didn't get prosecuted in state court. My experience of communicating with clients who get sentenced to prison versus at the state level versus the federal level is the experience is no prison is great. Let's be clear about that. But that it's a little better experience in federal.
Well, especially if the crime is not a major crime of violence,
right.
And it's not a lengthy sentence. There's the opportunity in the federal system to go with the whole prison camp.
Right.
And some of those prison camps, you could literally, theoretically, just walk right off and leave.
Yeah.
Of course, you would be silly to do that because the sentence is a minimal sentence usually.
Right.
You might as well do it and be done with it instead of being charged
with escape.
Which
is a serious sentence. So another really great, crazy-ass case of yours, and hopefully the viewers think the same of mine. Before we sign off, just remind everybody we're appreciative to our sponsors. There's always a sponsor at the end of our episode. It's one of our private investigators, and Down Low Investigations, so you'll hear their ad at the end. And I think we'll do another episode real soon.
And until then you're free to go.
Down Low Investigations is a sponsor of You're Free to Go. Behind every great criminal defense attorney is a great private investigator. That's why Mark and I use Down Low to investigate cases all over the country. Down Low can help you too, whether you're running a background check on an employee or running a background check on a blind date, or let's say you need someone followed or some other type of investigative work conducted. Down Low is the way to go. Call Download Investigations at 561-843-1806. Everything expressed and discussed in this episode are the opinions and experiences of attorneys Guy Fronstin and Marc Nurik and their guests. All ethical rules are complied with. Attorney-client privilege and confidential information is not shared or released during these episodes, and names, dates, locations, and other identifying information may be changed to protect confidentiality. Topics are embellished, and none of the statements made constitute legal advice and should not be considered or relied on as such.